Hi, my name is Caitlin Kelly, and I'm going to talk to you about the Terry v. Ohio 1968 case, which allowed police to pat down a person for safety reasons. On October 31st, 1963, while on a downtown beat which he had been patrolling for many years, Cleveland Police Department Detective Martin McFadden, age 62, saw two men, John W. Terry and Richard Chilton, standing on a street corner at 1276 Illucid Avenue and acting in a way the officer thought was suspicious. Detective McFadden, who was well known on the Cleveland police force to his skill in apprehending pickpockets, observed the two going back and forth along the same route, pausing to stare in the same store window. Each completion of the route was followed by a meeting between the two on the corner. The two men repeated this ritual alternately between 5 and 6 trips. They were joined by a third man of the name Katz, who left quickly after a brief conversation. Suspecting the two men of casing a job, Detective McFadden followed them and saw them rejoin a third man a couple of blocks away and in front of a store. So, in normal clothes, the officer approached them and identified himself as a police officer. And he asked them their names, and he mumbled something. So McFadden spun Terry around, patted his outside clothing, and felt a pistol in his overcoat pocket. He reached inside the overcoat pocket, but was unable to remove the gun. The officer ordered the three into the store. He removed Terry's overcoat, took out a revolver, and ordered the three to face the wall with their hands raised. He patted down the outer clothing of Chilton and Katz and seized a revolver from Chilton's outside overcoat pocket. He did not put his hands under the outer clothes of Katz, since he discovered nothing in his pat-down which might have been a weapon, or under Terry's or Chilton's outer clothes until he felt the guns. The three were taken to the police station. Terry and Chilton were subsequently charged with carrying concealed weapons. The defense of the charged individuals moved to suppress the use of the seized weapons as evidence on grounds that the search and subsequent seizure were a violation of the Fourth Amendment to the United States Constitution. Terry and Chilton were found guilty, and Intermediate Appellate Court affirmed the conviction, and the Ohio State Supreme Court dismissed the appeal on the ground that no substantial constitutional question was involved. So basically, the Terry case, Terry v. Ohio 392 U.S. 1968 case, was a decision by the United States Supreme Court which held that the Fourth Amendment prohibition on unreasonable searches and seizures is not violated when a police officer stops a suspect on the street and frisks him or her without probable cause to arrest. If the police officer has a reasonable suspicion that the person is committed, or is about to commit a crime, and has a reasonable belief that the person may be armed and presently dangerous, he can, be checked. For their own protection, after a person has been stopped, police may perform a quick surface search of the person's outer clothing for weapons if they have reasonable suspicion that the person stopped is armed. The reasonable suspicion must be based on specific and articulable facts, and not merely upon an officer's hunch. There has to be real evidence. So if, the guy was walking around with a suspicious guy, he had the right to go and check them out because they were very suspicious. This permitted police action as sequentially been referred to short as the stop and frisk, or simply a Terry frisk. The Terry standard was later extended to temporary detentions of persons and vehicles known as traffic stops. See Terry stop for a summary. The rationale behind the Supreme Court decision revolves around the understanding that, as the opinion notes, the exclusionary rule has its limitations. The meaning of the rule is to protect persons from unreasonable searches and seizures aimed at gathering evidence not searches and seizures for other purposes like prevention of crime and personal protection of police officers. Thank you for watching my video.